I would like to call this meeting of the House and Labor Industry Committee to order. Jonathan, please take the roll.
Dawkins,
Here.
Boyd, Brennan,
Don't leave.
Deloso, Donahue, Giroll, Green, Haddock, McNeil, O'Mara, Pisitano, Rozzi, Scott, Young, McKenzie,
Here.
Cooper, Diorsi, Ecker,
Leave.
Flood,
Leave.
Gleim, Ham,
Leave.
Jones,
Leave.
Kiefer, Rowe, Stambaugh. We have a quorum.
Thank you. Excuse me. Well, this morning we're going to be holding an informational meeting on worker misclassification, which occurs when an employee is misclassified as an independent contractor. We will hear from a range of experts on this topic as the committee continues its work passing legislation to implement the recommendations of the Joint Task Force on Misclassification of Employees. With that, is there any comments from the chairman?
Sure. Thank you, Mr. Chairman. So I welcome this hearing. I think misclassification is a problem that we want to identify and correct whenever possible. We also want to make sure that there are situations where individuals want to be an independent contractor, enjoy that flexibility, and enjoy that freedom, and that is allowed to continue as well. Those are two different options that people can select and choose, but we want to make sure that when they are opting into either one of those situations, that they are being categorized correctly by their employer and treated fairly in terms of wages, benefits, and other benefits. So we want to make sure that that is occurring. I would note that the misclassification task force was purely focused on the construction industry. That was the task and responsibility of that misclassification task force by statute. And so going beyond that purview is a stretch. And so using them as justification or using them as an expert in this area is also a stretch. So I think that just needs to be noted for the record that that was about the construction industry, not all classification in general. Thank you.
Thank you. We are joined today by our testifiers. We have the Minister, Rosalind Gilliard, which is a Spark driver and a Mon Valley Unemployed Committee member. Welcome. We also are joined by Julia Simon Michel, as on virtual supervisor attorney with the Philadelphia Legal Assistance. We also are joined by Paul Pendergrass, the Industry and Labor Compliance and Eastern Atlantic States Regional Council of Carpenters. Welcome. We also have Christopher Holluck, Deputy Secretary of Safety and Labor Management Relations of the Pennsylvania Department of Labor and Industry. Welcome, sir. And finally, we have Stephen Herzenberg, the Executive Director of the Keystone Research Center. I would ask all panelists to confine their remarks to 3 to 5 minutes so we can have all the members be able to ask questions of the entire panel when they are finished. We will go from our left to our right, beginning with the Minister Rosalind. You may start when you're ready.
Can you hear? Yes, I'm sorry. Thank you so much for having me here today. And thank you for all that you do. My name is Minister Rosalind Lane Gilliard. Since January 13th of this year, I have been a driver with the Spark Driver. This is a phone application which belongs to the Walmart delivery platform. Never had I worked as a delivery driver before. I performed any type of gig work before signing up for Spark Driver. My career has mainly been in both the corporate and nonprofit administrative sector, which included managing projects and staff, some grant writing, and other forms of nonprofit and community-based work as a minister. My last position had been with a nonprofit, and it was eliminated without much notice or severance pay. I began working for Spark Driver to generate immediate revenue and to supplement my unemployment compensation after enduring a month without income. As a driver with Spark, I am not free from control over how my services are managed. The Spark Driver app controls all aspects of my delivery work. Everything from the order in which deliveries are made to the prices customers are charged for said deliveries that are set, ruled and managed by the app. Often, excessive mileage is added to each trip, which contains multiple drops or deliveries, because I am not able to arrange the delivery orders in a rationally efficient manner that would reduce time, distance, and gas costs. While completing trips, I am not able to respond effectively to various traffic conditions. I am not permitted to establish proper pricing over what the customers are charged. In fact, I am not even informed on what Walmart charges the customers to see what my percentage of the earnings are per drop. I have no control over customer selection, what other retail deliveries Spark Driver may include on the trip. The Spark app limits my delivery times from 7 a.m. to 10 p.m., and the round robin function penalizes me if I choose not to take a trip due to low pay or mileage, traffic time, number of drops, relative pay and compensation to other trips, or the heaviness of the packages. If I encounter barriers that make it physically challenging or impossible for me to place the deliveries where the customers have specified, such as at the top of multiple flights of steps, on the side or behind a house or property at nighttime due to safety, I am penalized by the app's matrix. There are still a plethora of ways in which I have no control over my work with Spark Driver. Yet upon signing up for employment, they made it immediately known that I was an independent contractor. In fact, all of my paperwork was pre-filled, noting that I was an independent contractor and would receive a 1099 at the year's end for my services. After my exposure of working with Spark Driver, I realized that I am a misclassified worker. I am not the creator or founder of the Spark Driver app or operational model. My thoughts and opinions have not or ever been requested or considered in the functionality of the app or its concept. The misclassification of my work with Spark Driver has led to a detrimental impact on my finances. This includes excessive gas costs, mileage, compulsory maintenance required to keep my vehicle running and in proper condition to perform the work. Furthermore, the misclassification of my work with Spark Driver has caused a disruption in my unemployment or UC benefits, which were stopped. Please keep in mind that my living expenses, my medical costs, have never stopped or been interrupted. I was also ordered to pay back funds received from UC prior to my disqualification determination. And even after winning on appeal, proving that I was an employee and not an independent contractor, UC has still, to this day, refused to pay my multiple weeks of back payment. As an astute and educated individual, this situation has had a traumatic effect on my mental well-being. it is very painful for me to think that I allowed myself to become caught up in such a travesty. However, when faced with adversity, rather the loss of a job or otherwise, each of us can become vulnerable in ways we have never experienced before. This is why I am before you today, to ask for your help in fighting back against employers who misclassify their workers. As a citizen and taxpayer for over 40 years in the state of Pennsylvania, it is high time that I see a return on my investment in this state and receive the proper protections against predatory employers. Thank you.
Thank you, Minister. Next, we'll hear from Ms. Julia. You're muted.
Can you hear me now?
Yes.
Great. Good morning, Chairman Dawkins, Chairman McKenzie, members of the committee. Thank you for inviting me to speak this morning at the informational hearing. I am the supervising attorney of the Unemployment Compensation Unit at Philadelphia Legal Assistance. We are one of the only standalone expert practices in unemployment in the country, and we have seen consistent misclassification among our client populations over the 25 years we have been practicing and over my decade at Philadelphia Legal Assistance. Most of our clients who have been misclassified are not even aware that they have been misclassified until they walk into our office or until they apply for unemployment compensation, only to find out that there are no wages for them in the system. We typically see two types of misclassification, both pernicious in their own ways. First are businesses who treat a worker like any other employee, for all intents and purposes, all the trappings of employment, but then treat them differently for tax and pay purposes and send them a 1099 at the end of the year. Then you see situations like what was perfectly described by the minister, which are businesses who tell their workers that upfront that they are independent contractors, in fact, that they are partners, and treat them as such, again, for tax and payment purposes. What we know and what we heard from the minister is that this partnership is actually a facade, and that these individuals really remain at the whim of the companies for all of their assignments, feedback and evaluation, and pay structure. These are most often described as kind of the gig companies that we see in today's economy. Misclassification is a form of wage theft. I think it's really important to be clear about that. It is taking money out of the pockets of hard-working Pennsylvanians. It is also taking money out of the coffers of the Commonwealth, right? There are many victims when it comes to misclassification. For the individual, for the clients that we see, they often face a large unexpected tax burden because of the misclassification. They lose money out of their Social Security retirement. They don't have access to employer-sponsored health insurance or workers' compensation in case of an injury. And as we see most often in our work, they are often denied unemployment compensation. We see misclassification across the spectrum of different industries, right? We're talking about home health agencies, talking about different driving companies, delivering groceries. We've even seen it with certified nursing assistants. But the similarities across all of these areas remain the same, right? If you're looking at construction or these other areas, the basics of misclassification are similar. These workers have virtually no control over their assignments. They have their employers monitor them closely and hold them accountable to employer imposed rules. And each has had their pay determined entirely by their employer. When an individual who has been misclassified applies for unemployment compensation, they get a notice that says, sorry, you're not eligible because you didn't work and earn any money this past year. And that comes as a surprise to them because they've been working hard for a substantial period of time. But their employer has never reported their earnings to the unemployment compensation authorities because they misclassify them as an independent contractor. These individuals are often in a state of trauma from having lost their jobs. They already work on a kind of week to week living in terms of their ability to support themselves and have very little in terms of a personal social safety net. They often have to fight incredibly hard to ever get benefits and often can't do that without an attorney. The last thing I'd like to put before you, since I know we'll be talking a little bit about the recommendations of the task force today, is that I litigated the Supreme Court case Lohman versus Unemployment Compensation Board of Review, where the Supreme Court of Pennsylvania applied what we would call the AC test, part of the ABC test, and the test that determines employment and unemployment compensation law, and found that an UberX driver was indeed controlled by Uber and not engage in his own independent business, and therefore was in employment. I'm happy to talk more about that and any examples from my written testimony later today. Thank you so much for your time.
Thank you very much. Next, we'll hear from Paul.
Thank you, Chairman and members of the committee. My name is Paul Prendergast. I'm a compliance auditor for the Eastern Atlantic States Regional Council of Carpenters Industry, Labor, and Compliance Department. On behalf of our over 20,000 members in the Commonwealth of Pennsylvania, the Compliance Department monitors ongoing and completed construction projects throughout Pennsylvania and the rest of our region to ensure compliance with all state and federal labor laws. In the construction industry, misclassification is unfortunately all too common. It's not a union or non-union issue, a public versus private construction issue, or even an issue solely for the victimized workers. Misclassification of workers is an issue that impacts every taxpayer in Pennsylvania. Whether to gain an edge on the competition in the public bidding process, increase profit margins, or simply due to carelessness, both public and private contractors misclassify workers. Through misclassification, contractors keep their costs down by avoiding payroll taxes, unemployment and workers' compensation insurance, as well as overtime and other employee benefits. In failing to pay these obligations, these burdens are then placed on the backs of the taxpayers. In many cases, unscrupulous contractors seek out a vulnerable workforce of undocumented workers. These workers may not know their rights, and their immigration status offers a vulnerability that can be exploited by their employers. While Pennsylvania cannot prevent the exploitation of undocumented labor, the state can take steps to keep the profit out of exploitation. Our department has interviewed workers who have been manipulated into signing subcontractor agreements by their employer. Despite the terms of these agreements, the workers continue to function as employees, being directed where, when, and what work to perform for their contractor. Though nominally an independent business owner, these workers do not perform nor even seek work with other contractors. Act 72 has been a great resource in addressing misclassification in the construction industry. Since the implementation of Act 72, over $3 million in fines have been collected, money which represents money stolen from construction workers and missing tax revenue that would have otherwise increased the tax burden of hardworking Pennsylvanians. While Act 72 has proven to be a great step in addressing misclassification in Pennsylvania, there is still work to be done. The Department of Labor and Industry, as well as the Office of Attorney General, have worked diligently to implement and enforce Act 72. However, it's time to give the investigators the necessary support to ensure the continued success of Act 72. In 2011, the Bureau of Labor Law Compliance investigated 27 cases. In 2023, the BLLC investigated 249 cases. At first glance, this appears to show growth in enforcement. However, the Bureau's caseload has remained roughly around 200 to 250 cases per year for about the past decade. This information should not be interpreted to mean that there are only 250 cases per year. Rather, that appears to be the maximum caseload that BLLC can take on at current staffing levels. While the number of cases has grown from 2011 until the present, resource levels have not increased at the same rate. In 2013, the Department of Labor and Industry reported 27 investigators on staff. In March of this year, the department reported 27 investigators on staff. It is imperative that the legislature pursue improvements to Act 72, such as HB 1751, which this committee is familiar, which would build on the successes of the Act by allowing the department to retain recovered funds and increase their investigatory capacity. Act 72 has been a success for Pennsylvania's workforce and its taxpayers. The Eastern Atlantic States Regional Council of Carpenters support Act 72 and encourage the legislature to devote more resources to the investigation of misclassification, both in the construction industry and any other industry where workers are being victimized. All workers should receive the full pay and benefits to which they are entitled, and the Commonwealth of Pennsylvania must grant the necessary resources to protect all workers from manipulation and exploitation. Thank you for your time.
Thank you very much, Paul. Next, we'll hear from Chris.
Chairman Dawkins, Chairman McKenzie, and members of the committee, thank you for inviting me to testify today. My name is Christopher Halleck, and I am the Deputy Secretary of Safety and Labor Management Relations for the Pennsylvania Department of Labor and Industry. Employee misclassification is one of the most widespread, pressing problems facing Pennsylvania's workforce. In fact, worker misclassification is a problem the entire country is experiencing. Misclassification robs workers of the wages they've earned and precludes them from accessing essential protections the law confers on employees. This is also an issue about fairness. Misclassification unfairly benefits unscrupulous employers and deprives the state and local communities of desperately needed revenue. I am mindful that we have limited time today, and I will therefore rely on my written testimony already submitted, but I'm happy to answer any questions that anyone might have. Thank you.
Thank you very much, Christopher. Lastly, we have Mr. Ozenberg.
Now it's on. Okay. Good morning. My name is Steve Herzenberg. I'm an economist and the executive director of Keystone Research Center. I apologize for submitting my written testimony only about an hour before the hearing. In my remarks today, I'm going to make two main points. First, echoing some of the other folks we've heard from, worker misclassification is a widespread problem throughout today's U.S. economy, not just in the construction industry. Misclassification and deploy innovative enforcement approaches. Both these main points lead to a pretty straightforward conclusion for Pennsylvania. We should enact legislation that reduces worker misclassification throughout the economy, and we should seek to adopt best enforcement practices through a mix of legislative and administrative reforms. In terms of the broad reach and costs of worker misclassification, there's a body of literature that shows that misclassification exists among construction workers, yes, but also among truck drivers, janitors and cleaners, home health aides, retail workers, housekeepers, landscapers, customer service reps and call center workers, security guards, and delivery workers and manicurists and pedicurists. That's not the universe, but I mean, that's a body of occupations for which there's substantial research to document the prevalence of misclassification. The cost of misclassification is also high. The Economic Policy Institute, in a report that's referenced in my written testimony, did some estimates on the cost of misclassification in those 11 occupations I just ran off, including construction workers. And the midpoint of the range, the EPI uses a methodology with an upper bound and a lower bound, and folks can read the details on that. But if you pick the midpoint of that range, the cost of misclassification to workers goes from $5,500 a year for manicurists to and pedicurists to a high of $14,500 for truck drivers. And this is, if you don't know Economic Policy Institute, they're very careful. Their methodologies are often conservative, and that's the case here. In terms of the cost of misclass as a share of what people are paid, ranges in those 11 occupations from 20% to 27.5%, the highest cost, again, incurred by truck drivers. So it costs a lot. There's a very recent study released in May, which kind of documents how little some of the most visible misclassified workers get. These are Uber drivers, passenger drivers, and delivery workers, a study that looked at data from 5 cities, 52,000 trips of over 1,000 drivers, 3 of the cities in California, and then Chicago, Boston, and Seattle. And partly the study was exploring whether or not people are paid 20% more than the minimum wage in the relevant jurisdiction. That was a promise in the California Proposition 22, a gig company-sponsored 2020 California ballot measure. And the bottom line of this study is that drivers didn't make the minimum wage in any of these places. In the California places, once you net out costs, they made $7.63 an hour with tips, less than half the $16 an hour California minimum wage. EPI also estimates the cost to social insurance programs, and again, it's thousands of dollars. A worker, and the high end of those estimates are $3,000 a worker in terms of contributions to unemployment compensation and other social insurance programs. And again, there's also some evidence on the cost of misclassification in the joint task force that Pennsylvania published. There's also a reference to an older report that Keystone did in 2019, again, with a series of state studies on the cost and prevalence of worker misclassification. That literature is focused more on construction, but again, a bunch of the other sources that I've made reference to are looking at other occupations. So now to the second main point, the innovative enforcement practices. We've already heard a little bit from an actual lawyer as opposed to an actual economist about the ABC test. And so a few states are broadly, in a couple cases, or narrowly in a lot more cases, using, again, what's called a three-factor ABC test for independent contractor status. Work is done without the direction and control of the employer. The work is performed outside the usual course of the employer's business. The work is done by someone who has their own independent business or trade. If you don't meet all of those conditions, you're an employee, not an independent contractor. Other jurisdictions, including the federal government, have sought to clean up their language, not necessarily adopting precisely an ABC test, but nonetheless seeking to tighten up language so that people are not so easily misclassified, and so that the law is clearer. Again, there's a reference to an EPI brief, a different brief, which shows that 17 different states have adopted an ABC test for purposes of unemployment compensation enforcement. 6 states have done it for wage and hour, other regulations across all industries, with 3 additional having done so for construction. And then there's some specific examples of effective enforcement, which include things like, higher penalties. In general, across the country, the kind of 4 intertwined trends in innovative enforcement, distinct from an ABC test or clarifying the law in terms of who's misclassified and who's not. Many localities and many state attorney general's offices have established their own enforcement offices. Pennsylvania did that when Governor Shapiro was attorney general. Philadelphia has established its own enforcement office. Allegheny County is in the process of setting up one. Second, learning in part from federal USDOL enforcement, a bunch of states have sought to adopt more strategic industry-specific approaches, including proactive targeting of some investigations and using publicity to bring attention within an industry to sanctions imposed on violators, with the idea of deterring violations. Third, a few localities, San Francisco and Seattle, for example, have funded worker centers or other community organizations embedded in neighborhoods from which exploited workers come. These can become the eyes and ears of state and local enforcement entities, substituting for labor unions in industries or industry segments where there's low union density. And then a fourth trend has been increased data sharing within, for example, state or local government, or sometimes between state governments and the Federal Internal Revenue Service. Again, the reality is that employers that violate, that misclassify workers and violate unemployment compensation and pay below the minimum wage, and sometimes violate child labor laws, they tend to be the same employers. So if you can get your databases across your different enforcement efforts of different laws and sometimes different agencies to talk to one another, then once you nail an employer in one area, you can, nail them and take appropriate action otherwise. So back to the bottom line. So one more point I want to emphasize. In terms of those innovative approaches, we've heard from the carpenters and heard from labor and industry. Your enforcement has to be resourced. Whether it's inspectors or it takes money to become more savvy about a particular industry. It takes money to work through data sharing issues and the IT challenges that are posed by those. Bottom line, thanks to the good work of the Joint Task Force on Worker Misclassification, the follow-up work of this committee, the reform efforts that have begun at the Department of Labor and Industry, Pennsylvania is well positioned to join the ranks of leading states when it comes to rooting out worker misclassification and enforcing labor standards in general. Congratulations and keep it up.
Thank you. I want to thank all of our testifiers today. We're going to open up some questions to some members. Let's start with our chairman.
Thank you, Mr. Chairman. I appreciate the testimony of everybody here today. I think it is helpful to hear from people across the spectrum here on this particular topic. And Mr. Herzenberg, Dr. Herzenberg, do want to thank you for bringing up proper reporting of all different types of violations and how we should maintain different databases, child labor violations, the use of illegal labor. We're seeing increases in both of those instances across this Commonwealth, and I've offered amendments to have proper reporting on those things. Unfortunately, the majority party has voted those amendments down in this committee every single time, and that is a real shame because we do need to have proper reporting. We do need to have accountability of those employers who are utilizing and exploiting children and illegal immigrants, and the majority party votes against that every single time in this committee. I do have questions for the minister because you are the one person employed in the gig economy here, so I really appreciate your testimony. You hear lots of different stories across the gig economy. Some people love it. It works very well for them. They make additional wages on the side. Maybe it's part-time work supplementing. Maybe it's just that they want to have the flexibility that they get in that job. So all different types of people. Some people enjoy it. Some people clearly don't. So I'm not going to generalize or characterize anybody's experience in general. But I do know the end users, obviously customers of these different programs, really appreciate the final product and the end service. So I think we have to recognize that as well. I do have some questions since you've shared your personal experience, and particularly concerning, you said that it was detrimental impact on your finances. Obviously, not a situation we want to find somebody in where they are working, but end up in a detrimental situation for their finances after performing some kind of work. So to help us understand as a committee what we can do to help you and others in your situation, I do have some questions here. So you said you started on January 13th of this year, is that correct?
That's correct.
And did you start driving right away?
January 13th was the date I started driving. I applied for the position right after I lost my job 5 days before Christmas.
Okay. And so you took your first trip on January 13th?
January 13th.
Okay. And you've been driving continuously?
No.
Okay. Can you tell me about that experience?
I took my first trip January 13th. Mind you, my unemployment had not began yet. I worked that week, and then you file your unemployment on a weekly basis. I generally do it on Sundays, the first day. Being the astute individual that I am, when the unemployment system was doing a lot of thinking about the information I was putting in, meaning each time I responded to a question, it was taking longer than it had taken me the last couple of weeks before, I began to feel that there was a problem. And then at the end of the filing, it told me that my claim was under, I forget the terminology, but it was being decided upon. So I said to myself, oh, that's a problem. I probably shouldn't do this anymore. So I only did it for that 1 week. I did not do the gig work the following about 3 weeks. Then it got to the point my savings, my living expenses were there. I was not receiving unemployment. I was getting no income. So as I pursued with unemployment, they kept giving me the runaround. But finally, it was in February, mid-February, I believe it was around the 10th or the 11th, where they gave a decision that I did not qualify. And so they immediately closed my claim. So then now, when you get a decision from unemployment, you can appeal that decision. And they tell you that while you're awaiting the appeal, that you should continue to file your unemployment claims. Now, mind you, I qualified for unemployment from my initial job. They closed me down, they shut me out. The system would not let me in. It would not respond to me. Nothing. I sent emails, I made phone calls, nothing. Weeks. And it wasn't, so then in about the 3rd week or so of February is when I made up my mind that I guess I needed to do this gig work after looking for other work as well and not receiving anything immediately. And it was instant income, even though I'm putting out a lot in gas, mileage, maintenance. Every time I make a delivery, the payment hits my account. So, my mind was just, I needed income.
Totally understood, and I appreciate that insight. I know I saw in your testimony and heard that you are appealing your claim or working through that process. If you need additional help with the UC system, we have somebody from the department here, and members of the committee. We would be happy to help you look into that claim or whatever we can. As
This
you're going
is
through
my
that
second
process.
appeal, and I'm sorry to interrupt you, but I
That's
want to
okay.
make that clear.
I don't want to skate over that. That's an important thing that we want to make sure somebody receives their proper benefits. But I want to get back to specifically talking about the misclassification or potential misclassification and your work. And so you drove for a week and then you stopped. And
Yes.
then when did you start again?
It was about a month later, about
Okay.
the 3rd week of February.
Okay. And so you've been working then since February
Yes.
through now consistently doing this?
Yes.
Okay. And roughly how many hours a week do you do? Doesn't need to be exact, just so I understand.
Oh, I can give you exact from days because in order to make any money, I have to work at least 10 to 12 hours a day.
Okay.
When I first did it, I did it every single day, 7 days a week, because that's what my expenses counted for. So the only way that I was able to see revenue, because at the beginning, the app is still manipulating. So the first few hours, it casually sends you things. It doesn't go. It's not until you've been on the app and out in the field for a number of hours, 5, 6 hours, where it'll start to just pick up and give you things regularly.
Okay.
So I work 10 to 12 hours a day.
Okay. And you've been doing that for the past couple months, you said.
Yes.
And so then roughly, again, don't need exacts, but how much, have you calculated how much you've made? Is it, have you calculated it by hours or overall, or kind of just, again, I'm trying to understand what kind of compensation you're receiving through this work. And so how do you factor that, or how have you looked at it?
So I have calculated to a degree. Before I answer your question directly, I do want to emphasize I have not completely calculated what I'm putting out,
Just so we
but
get
I
an
have a
understanding.
large guesstimate because the put out is massive.
Okay.
My car, I had a new vehicle. I had an oil change that was done on the 28th of December. My car's a newer car. I don't need oil changes until like 5,000 miles as opposed to 3,000 miles. In February, when I started, after the 2nd week of me going back to the gig work, my car told me it needed to have maintenance, which was another oil change. I said, I couldn't have put miles. I did. The dealership confirmed it. I put over 3,000 miles in a matter of 2 weeks on my vehicle, wear and tear on my tires, the gas, every single day. My tank is depleted in the middle of the day, and then I have to fill it up. I have an SUV that's at least $50 to $60 a day that I'm putting out.
Oh, I
So with-
understand that
so that's-
inflation driven by bad policies in our federal government is crushing people when it comes to energy. So, again, can you tell me how much you
Yes.
earn?
So I preface with that because, again, it's like a vicious cycle. You're putting out, but you're also getting back, and you're getting back immediately, which is what has me in this cycle. So the weeks when I've worked the 7 days straight at the 10 to 12 hours, sometimes 14 hours a day, there was a week I made a little over $900. Then the weeks when because my body could only keep that up for about 2 weeks, so I had to start taking days off. So I take on average a day off now, and then depending on my schedule, I'm working 8 to 12 hours a day, and I'll make sometimes 400, almost 500 in a week. There are days where, because I am an active minister, and I have responsibilities there as well. So there are days or weeks, I may only be able to work a few hours each day. And those are the weeks that are difficult for me because it's only if it's $200 after working 40 hours in a matter of a 3-day period, because I'm working maybe 5 hours, not quite enough time to start getting the regular gig offers, but I have to stop because I have another obligation. Then the next day I go out, I'm spending a few hours, I have to have another obligation, so I have to stop.
Sure. So this position gives you the flexibility to be a minister and then work on your own schedule.
It does not give me the ability to work on my own schedule. I adjust my schedule to how I've learned the app to
But
react,
you
if
get
that
to
makes
decide
any
when
sense.
you open the app and start performing and when you don't.
I do.
Okay. Okay.
That part I do.
Okay. So, and all of these earnings, I assume, as you should, you would have reported those to UC when you went
Certainly.
to claim your benefits. And so then you're saying that making between $400 to $500 on the low end, $900 on the high end, you were per week, you were working, earning an income, you reported it to UC, you didn't receive the UC benefits, is that correct?
Correct.
And then you appealed, is that correct?
So let me back up. When you say I was working, so the UC benefits that I'm referring to that I have not received, that month or 6 weeks when I was not working, making any income, they have not given back to me, even though a referee decided in an appeal that told me to tell them to open my case so I could and backdate the claims and that they would do it for me. And they did that and came back with a decision that because I didn't file, my case was locked, I couldn't get in. But because I didn't file, they couldn't give me the weeks. So this is my second appeal.
Okay.
So it's those weeks that are that I have not received payment for.
Well, I think I've asked enough questions at this point to gain an understanding of your situation, and I appreciate that. And again, I think it's very helpful as we go through this process. Hopefully, we'll hear from other stakeholders. Again, I know people personally who have done this type of work, and it's worked for them. So again, I don't think we should be generalizing based off of one person's experience, even though I value and appreciate your testimony here today. And so I think we can continue to look into this matter, but again, I think we do have new innovative types of employment and opportunities for individuals to provide for themselves and their families. We also have new innovative services that are being provided, and so we want to make sure that, before we make any changes, we are not doing something that would be detrimental to a large number of stakeholders and users. So do appreciate your testimony, and again, I think it'll be helpful as we move through the process. Thank you again.
You didn't ask the question, that last comment, but may I respond? So when you say you know people personally that do this position, the type of various gig work, and it works for them, well, after my exposure, I know a lot of people that do this type of work, various industries, from Uber drivers, Lyft drivers, Instacart, etc. My experience has been that, and it is situational, but the ones that it works for generally are ones that they have other income. They may be housewives who have a spouse that is providing for the household, and they have a second vehicle, not their primary vehicle. They have a second vehicle that they can put wear and tear and mileage on and beat that vehicle into the ground. And because they're getting out, because I'm talking with these people as I'm out, I'm even delivering to some of them. So like the woman that told me she was a gig worker and she had a cast on her foot and said that she was getting no compensation, and she broke her foot on someone's steps, telling me to be careful on her steps because she didn't want the same to happen to me.
Thank you very much. Now, Representative Haddock.
Thank you, Mr. Chairman. Reverend, the Spark app, when you applied, was that in person, cell phone, on the computer?
It was both. I had to end up completing it on the cell phone because I went to the computer.
So not in person. Thank you. And the Spark app, when you applied, did it show blatantly, or did you understand that you were not becoming an employee, but actually you were going to be classified as a independent worker, contractor? Was that clear?
It was very clear that the terminology that I was to be an independent contractor with a 1099. And so with that understanding myself, I said, oh, okay, well, I can do this kind of self-employment now.
And in your life, did you ever experience and become a 1099 independent contractor before? Have you had exposure to that? And would you have known the ramifications of taking that position?
No, I have not. No and no.
All right. And you mentioned you won an appeal with our system, and you had to, and you still haven't received your money on the workers' unemployment from the UC.
Correct.
And now you're into your second appeal because of an issue with the system.
Correct.
And the time frames of that? Do you have a rough idea of when you filed your appeal to winning it to not receiving the money?
So the appeal was filed
Approximately.
in January. I worked that first week. Around maybe a week and a half or so before they gave a decision. But I should say the decision only came because by then I sought help. And the help that I sought was meeting with the Secretary of Labor and her people on a weekly basis and mentioning my name and my situation. So I was initially told my appeal could take anywhere from 8 to 12 weeks, but my appeal ended up, I ended up being able to file my appeal about a week and a half after the decision, and it came up about 4 weeks. It was March 9th was my appeals hearing, but I'm the exception. because
and when you won, though, that's okay. I'm sorry that you're having this difficulty, but when you won, do you know the dollar amount that you were awarded?
I didn't get it.
Okay.
I won, but they didn't pay me.
Do you know the dollar amount? Did they award you a figure?
So they didn't specify the figure, but the referees specified the weeks that needed to go back, because I could not, even though my name was being mentioned, my situation was out there,
Did somebody
I
advocate
still
for
could
you?
not
Good.
go in. It blocked me. I could not file weekly claims.
Okay. That's a terrible situation, and we will get you the help to, we will try to get you the help to get this resolved. You deserve the money that you worked for, and you should receive it, and everybody else that's in your boat should receive a faster turnaround from labor and industry.
Thank you.
Thank you.
Paul, from the carpenters, very similar situation where workers are misclassified as independent workers in Act 72 and by the commission. Many cases were very similar to the ministers, where they were misclassified unjustly, and it was proven that they truthfully weren't independent contractors, correct?
Yeah, that's correct. Oftentimes they're given forms and they sign them being told one thing, but in actuality, they're now classified as an independent contractor and not an employee.
Okay. And if other industries, because comments were made that the commission was only looking at the carpentry industry in particular, would you guess that, or would you say that if the same guidance was given to other industries, that we would have the same problem, and that other employees in other industries would be paralleled to the carpenters and found that they're misclassified?
I'm sorry, I don't understand your question.
So in the carpenters, we have proven that many employees were misclassified as independent contractors. If other industries were afforded the same coverage as Act 72, do you think that this would apply to other industries as well?
Yeah, I don't really have the experience with the other industries, but it would be my guess that it would apply to a lot of other situations and help a lot of other workers.
Okay, thank you. And Chris, in labor and industry directly, in the last 2 years, in 21 and 22, the penalties that were recovered were about $610,000. And in this year's budget, the governor's looking for 12 more employees just to work on misclassification issues within. What would you think, with the 12 extra positions that the governor's looking for, how would that help labor and industry, and what would you think your projections may be as to how rampant and what they may find if you had the proper workforce to enforce?
Thank you for your question. If I could just very quickly echo what has already been said, but absolutely, I don't work for our Bureau's unemployment compensation division, but I'd be happy to get your information. Under the leadership of Secretary Walker, it's a priority to do everything we can to get people their benefits, and to interpret the law as favorably as possible to help people as much as possible. So I'll be happy to get your information afterwards and take it back to my colleagues and to pass that message along. And I'd also, if it's okay, echo your last question, jump on real quick. And absolutely, misclassification is beyond just the construction industry. It's prevalent in the across many industries. We heard earlier, janitorial, home health care, trucking, janitorial. Our agency's Center of Workforce Information and Analysis, our economic department, they estimate that there are approximately 185,000 misclassified workers across all industries in Pennsylvania. So I just want to add that to your last question. And finally, a lot of the issues that we see in my bureau, labor law compliance, stem from a lack of education. It's all over the scale of people intentionally avoiding and taking advantage of a confusing landscape, down to innocent people and contractors and businesses who don't know what the law requires. There are a number of reasons for this. There are varying laws and varying tests that exist across the employment laws we have in Pennsylvania, in addition to common law. So one of the major priorities that we would have if we were afforded more staffing, which has not been increased in over a decade. We've had 27 investigators that enforce not just Act 72, but 13 labor laws across the entire Commonwealth. And if we get more resources, they will not be working on just misclassification. They'll be working on all of these areas. We've seen a massive increase in child labor. We've seen a massive increase in minimum wage violations. The violations are going up every single year. So these investigators would go towards a number of laws. In the misclassification space in particular, what we would be able to do is educate people more. We would be able to bring some clarity to people and employers and workers to know what the law requires and hopefully try to stop the issue on the front end. We would also be able to be more vigorous in follow-up investigations and just to hit more job sites. So there are a number of areas that we would be able to use those resources in the context of Act 72 and misclassification, but it's well beyond that as well. The entire Bureau has gone a long time without additional staffing, and it's becoming a real challenge to enforce the laws that we are tasked with enforcing.
Thank you. Thank you, Mr. Chair.
Thank you. So we have roughly about a minute to left. I know we have Representative Glime and DeLoso. If it's okay, you both can go. We can't have any more questions. You can make a statement just so we can have enough time to get both of you in.
Thank you, Mr. Chairman. I'll just make a statement real quick. I'm kind of hoping that in the misclassification of employees' final report and the joint task force that was done in 2022, that they talked a little bit about COVID and how a lot of employees after COVID wanted to remain working from home and have the ability to work two jobs as well and have a little bit of autonomy there. Last year, we passed a financial literacy bill out of education, and I really think that we have a whole generation that has absolutely no idea what a W-2 is or a 1099. Like, they just don't understand what they are, why they need them, how to do their taxes, the actual literacy part of getting a job and filing your taxes and how you are classified, whether you're an employee or not an employee. But I think that can be added in, honestly. I think we need some education around that. So thank you.
Thank you very much, Representative DeLoso.
Thank you, Mr. Chairman. Real quickly, I wasn't here when Act 72 was enacted. I was leading my Teamsters union, and I got a phone call saying, "Hey, Dave, where's your lobbyist? You're getting written out of this bill." All right, because I'm in trucking. So I went on a search. I had to find out why we got written out of this bill, and I went to my senator, and I said, "Senator, what's going on?" He says, "You're late to the party. FedEx has been here already." Fact of the matter is, trucks don't make money, cars don't make money, multi-passenger vehicles to move Uber people around with don't make money. It's a depreciating asset. The person actually conducting the work makes money. There has been a model adopted by corporate America that, it's a downward push. We're not going to invest in vehicles because vehicles don't make money. So we're going to pick a static number where we think we can get someone to do as much as we can possibly get out of them without them rejecting us, and they can figure out how to make money. All right, our money's fixed. We're getting 10% of the revenue. This is corporate America. We're getting 10% of the revenue or whatever. And in the construction industry, it's worse. All right, because trucking, I know trucks don't make money. I bought my own truck. Matter of fact, I own two of them, tried my hardest. Fact of the matter is, until we in this state demand wages commensurate for the work that's performed, and benefits and retirement security, and demand that at least when we spend our state tax dollars, that the person on the working end gets what they deserve, regardless of whether or not their truck makes money. All right, because in my business, in construction, trucking, in the Teamster world, you know, my total package is about $65 an hour. Now, that's my wages, my benefits, my paid time off. It's about $65 an hour on straight time. Now, an independent contractor isn't bound to do a certified payroll for himself, or at least I think we've modified that. They may have to now, but they don't have to pay themselves $65 an hour. They don't have to roll the money into a bona fide defined benefit pension plan. They don't have to give themselves excellent health care, and they don't have to pay themselves the appropriate wage. And the appropriate wage starts from the moment you get in the truck until you get out of the truck. So you may drive 45 minutes to the job site and then 45 minutes home. Well, now a responsible contractor has to pay that hour and a half travel time, and he has to figure that into his bid. So the union guy puts a bid in at $110 an hour per truck. The independent puts in a bid at $84 an hour. I guarantee you, you run around this state right now, somebody is out there in a $115,000 dump truck, putting fuel in it, driving an hour and a half to work, working on a job for $84 an hour. The math just isn't there. At the end of the day, the person doing that is barely making wages. You know, we have, I say we, that's incorrect. There is an aggressive package of bills out there to address the gig economy, to address the inadequacies in our contractor language. Fact of the matter is, I can get them all printed up in 15 minutes and drop them on the desk, and they're going to pass this committee 15 to 10 and go to the Senate to die. Until we make a decided shift in favor of employees, things are not going to change. You know, good on you, building trades. Act 72 is working modestly. It's better now than it ever was, but it's still not right. And with the COVID and the influx of the gig economy, it's gotten worse. We have more and more people, including school bus drivers, being paid via 1099 right now. Can you imagine that you lost your Teamster job in a bidding war and the incoming carrier is now 1099ing the drivers? How did you become an independent contractor driving a school bus? It's absurd. And that's taxpayer dollars. And frankly, the state has missed the ball on millions upon millions, if not billions of dollars in general fund revenue that should be returned to the workforce. It should be returned to the workforce by way of progress and the people of this great Commonwealth. It's, like I say, it's fair time that we get both sides of the aisle pushing in the right direction. Thank you, Mr. Chair.
Thank you very much. And I know we ran over a little time, but I want to thank all of the testifiers for being here today and provide us with their testimony. We absolutely look forward to working with our colleagues on both sides of the aisle to continue to move this meaningful legislation. I can tell you this committee has started off moving in that direction. We've had two bills, 1748 and 1751. Unfortunately, we had, like the previous speaker said, it was a party line vote, which means we still haven't convinced the other side that workers matter. And we have to do a little bit more work to get there. But as I always say, it's what we do now that matters. We can't look to the past, because we know the past 12 years did nothing. So we have to move forward and do something. And as the comment was made around the joint task force only being focused on one industry of construction, that's not true. Those recommendations made for several other industries, and they all kind of came back to the same conclusion. When we do not educate or treat our workers fairly, then the pay rate is going to be affected by individuals like the minister who's putting in 14 hours a day and barely making it, have more than money at the end, which is problematic. We are a better state than that. We're looking forward to advancing more legislation in the coming weeks, and we hope that at some point we can get our colleagues to join us and actually stand up for workers for once. So with no further business in front of this committee, we are now adjourned. Thank you.